They thought she was just another suspicious black woman trying to get into a gated community, until they realized the woman in handcuffs at her own front gate was a sitting federal judge, and by the time the night was over, 2 police careers were already collapsing under the weight of a decision driven by ego, assumption, and racial bias. The evening of March 3rd began like any other for U.S. District Judge Naomi Whitaker, who left the federal courthouse in downtown Atlanta at 7:38 p.m. after a long day presiding over a civil rights case involving allegations of excessive force by municipal officers, unaware that within the next hour she would become the subject of the very constitutional violations she had spent her career analyzing from the bench. At 46 years old, Judge Whitaker had built a reputation inside the United States District Court for the Northern District of Georgia as meticulous, restrained, and unshakably committed to the 4th and 14th Amendments. A former federal prosecutor who had clerked on the 11th Circuit and earned confirmation to the bench with bipartisan support. And that night, she simply wanted to get home to her 10-year-old son Caleb, heat up leftovers, and review draft opinions before bed. She drove her Navy Tesla sedan north toward Briar Hollow Estates, an affluent, gated enclave in North Atlanta where property values exceeded $1.5 million, and where she was one of only 4 black homeowners among 142 residences, a fact she was reminded of periodically by lingering stares during morning jogs and neighborhood emails describing unknown individuals who looked remarkably like her relatives. At 8:11 p.m., she pulled up to the wrought iron security gate, lowered her window slightly, and tapped her registered electronic access fob against the sensor, hearing the familiar confirmation beep and watching the green indicator light flash as the gate began to slide open, a routine she had performed hundreds of times before. But before her vehicle could roll forward, she saw red and blue lights ignite behind her, washing the gate in flashing color as 2 marked cruisers from the Atlanta Police Department pulled in abruptly and boxed her in from the rear. Judge Whitaker's legal instincts sharpened immediately, her mind shifting from fatigue to analysis as she placed the car in park but kept the engine running, raised both hands to the steering wheel in plain sight, and checked her mirrors as 2 white male officers exited their vehicles with purposeful urgency, hands resting near their holsters in what training manuals describe as a ready position. The taller of the 2 approaching her driver's side window, while the second moved toward the passenger side to create a containment angle. The taller officer, whose nameplate read Hurst, knocked sharply on her window and gestured downward, and she lowered it halfway, keeping her hands visible, as he said, "Ma'am, step away from the gate. This is private property." A statement so fundamentally illogical given the open gate and her functioning access fob that for a brief second she wondered if he had mistaken her for someone else. "Officer, I live here," she replied calmly, her tone measured and precise in the way she addressed attorneys in her courtroom. "I just used my key fob to enter my residence." But Hurst's expression did not shift, and he responded, "We received a call about a suspicious person attempting to gain entry. I need you to step out of the vehicle and provide identification." And in that moment, Judge Whitaker processed the constitutional framework unfolding in real time. A potential investigatory detention under Terry v. Ohio would require reasonable suspicion particularized of her conduct, yet she was using authorized access to enter her own neighborhood while dressed in a Navy judicial suit with her courthouse badge still clipped to her bag, and nothing about that sequence provided articulable facts of criminal activity beyond the color of her skin. "I am United States District Judge Naomi Whitaker," she stated evenly. "This is my home, and you are detaining me without reasonable suspicion." Words that should have triggered immediate verification and de-escalation. But instead Hurst stiffened and said, "I don't care who you claim to be, step out now." A phrase later replayed in court dozens of times. She made a deliberate decision then, weighing risk against principle, thinking of her son waiting inside and the statistical realities of escalation during roadside encounters, and she said clearly, "I am stepping out under protest, and I want it on record that I have identified myself and informed you this detention is unlawful," before slowly exiting the vehicle with visible, deliberate movements and retrieving her federal judicial identification and Georgia driver's license, announcing each motion before making it. Officer Luke Dennison stood several feet away, silent, watching, Hurst took the identification and returned to his patrol car for nearly 7 minutes while Judge Whitaker remained standing beside her vehicle, hands loosely clasped in front of her, aware that the subdivision's security cameras were capturing every second and that a neighbor's porch light had flicked on down the street. Dispatch audio would later reveal that the suspicious person call had originated from a different gated community 2 streets away, with a different street name entirely, and that dispatch informed Hurst the addresses did not match, to which he paused and replied, "She fits the description." Despite the description being limited to dark sedan and female, categories broad enough to encompass thousands of residents. When he returned, his posture conveyed not resolution but entrenchment, and instead of apologizing he said, "I'm going to need to search your vehicle," prompting Judge Whitaker to ask, "On what legal basis?" In the same steady tone she used during suppression hearings. "You were acting nervous," he responded, and she answered, "Being approached aggressively by armed officers is not reasonable suspicion," citing case law almost reflexively. While Dennison shifted his weight but remained silent, Hurst then said, "Turn around and place your hands behind your back. You're under arrest for obstruction." And in that instant the line between mistake and misconduct was crossed, because obstruction requires interference, not verbal assertion of rights. And Judge Whitaker looked directly toward the body camera affixed to Hurst's vest and stated, "I have complied, provided identification, and informed you of a constitutional violation. This arrest is retaliatory," before turning slowly and placing her hands behind her back as the metallic click of handcuffs echoed against the iron gate of her own home, the gate that had opened for her seconds earlier, now framing a scene that would soon travel across every major news network in the country, because within the next 48 hours the footage would go viral. Federal investigators would take notice, and Officer Daniel Hurst would discover that the woman he chose to arrest for entering her own property was not merely a resident. She was a federal judge who understood precisely how to dismantle a career built on unchecked authority. The officers thought the worst part of the night was over once the handcuffs clicked shut, but in reality that metallic snap was the beginning of a federal investigation that would unravel not just 2 careers, but an entire pattern of misconduct inside the Atlanta Police Department. Judge Naomi Whitaker was transported downtown in the back of a patrol car, still composed, still methodical, already constructing in her mind the constitutional framework that had just been violated, while Officer Daniel Hurst drove in silence, and Officer Luke Dennison avoided eye contact. The radio traffic later revealing that dispatch had once again reminded Hurst the suspicious person call originated from a different neighborhood entirely, a fact that would become central to what followed. At 8:49 p.m., she was escorted into the booking area, and the desk sergeant froze the moment he looked up from his computer and recognized the name on the identification being handed across the counter. "You arrested a federal judge?" he asked, the room falling quiet as officers within earshot stopped mid-conversation. Within minutes, a watch commander was summoned, and within minutes of that, phone calls began climbing the chain of command, first to the precinct captain, then to the chief's office, and then, critically, to the U.S. Attorney's Office for the Northern District of Georgia, because arresting a sitting judge of the United States District Court for the Northern District of Georgia is not a routine booking error but a constitutional event with national implications. Body camera footage was pulled immediately and reviewed internally that same night, and what supervisors saw made their expressions shift from confusion to alarm to disbelief, because the video showed Judge Whitaker calm, compliant, identifying herself, warning of constitutional violations, and citing case law while Hurst ignored dispatch clarification about the wrong address and escalated anyway. By midnight she had been released without charges, personally escorted home by a senior supervisor who offered repeated apologies, but Judge Whitaker did not engage in small talk during the drive. She was documenting timestamps, statements, tone, posture, and sequence, because she understood something the officers did not. Intent could be inferred from conduct, and the record was devastating. By sunrise the next morning, word had reached senior officials at the Department of Justice in Washington, and by Sunday evening the FBI Civil Rights Division had opened a preliminary inquiry under 18 U.S.C. Section 242 for deprivation of rights under color of law, a statute carrying potential prison time if willfulness could be proven. Monday morning, The story broke publicly, first through a legal affairs reporter in Atlanta and then nationally within hours. And when the 47-minute body camera footage was released, it spread across social media at staggering speed, legal analysts pausing frame by frame to highlight the moment Dispatch confirmed the address discrepancy and the moment Hearst said, "I don't care who you claim to be," a phrase that commentators from Harvard Law School described as textbook retaliatory escalation. Community reaction was swift, with civil rights groups organizing press conferences and demanding an independent audit of stop-and-arrest data. And under mounting pressure, the mayor announced full cooperation with federal investigators. What the FBI uncovered over the next 8 months expanded the story far beyond a single gate encounter, because statistical analysis of Hearst's stop patterns showed black drivers in his patrol zone were detained at nearly 4 times the rate of white drivers despite comparable crime rates. And internal affairs records revealed 9 prior complaints alleging racial profiling, each dismissed as unfounded without comparative data analysis. Radio transcripts demonstrated that supervisors rarely scrutinized his discretionary stops, and email correspondence suggested informal tolerance of aggressive tactics so long as arrest numbers remained high. Investigators interviewed residents who described similar experiences near gated communities and upscale neighborhoods, where entry credentials were questioned more frequently. When the resident was black, the pattern transformed the case from an embarrassing mistake into a potential civil rights prosecution. And a federal grand jury was convened to determine whether Hearst's actions met the threshold of willful deprivation, meaning he knew he lacked lawful authority yet proceeded anyway. During grand jury testimony, dispatchers confirmed they clearly communicated the incorrect address, and video evidence showed Hearst pausing before saying, "She fits," a statement prosecutors argued reflected reliance on appearance rather than articulable conduct. Officer Dennison, though less vocal during the arrest, was scrutinized for failure to intervene, because federal courts have increasingly recognized that officers have an affirmative duty to prevent constitutional violations when feasible. As weeks turned into months, the department placed both officers on administrative leave, and the chief announced an external review of racial disparity data. But critics argued reforms only followed public exposure. Inside legal circles, the case became a teaching example in judicial conferences and law school seminars. Not because the victim was a judge, but because the footage demonstrated how rapidly ego can override procedure when authority goes unchecked. Judge Whitaker herself declined most interviews, issuing only a brief written statement emphasizing that the Constitution applies equally at gated entrances and city streets. Yet behind the scenes, she cooperated fully with investigators, providing a detailed affidavit outlining each procedural misstep, from the absence of reasonable suspicion to the retaliatory arrest unsupported by probable cause. By early spring, the grand jury returned indictments charging Hearst with civil rights violations and false arrest, and charging Dennison with aiding and failing to intervene, marking a rare but powerful step in federal accountability. The announcement was delivered at a press conference where the U.S. Attorney stated plainly, "No badge authorizes retaliation against a citizen asserting constitutional rights." And as cameras flashed, it became clear that what began as flashing lights behind a gate had evolved into one of the most closely watched civil rights prosecutions in the region's history, setting the stage for a trial that would force a jury to confront not only what happened in those 47 minutes, but why it happened, and whether willful blindness to bias could carry criminal consequences. The trial began nearly a year after the arrest, in a federal courtroom in Atlanta, just floors below the chambers where Judge Naomi Whitaker normally worked, a detail not lost on jurors, as Officer Daniel Hearst and Officer Luke Dennison sat at the defense table facing the very judicial seal they had sworn to uphold. The prosecution, led by attorneys from the Civil Rights Division of the U.S. Department of Justice, framed the case not as a mistake made in haste, but as a willful decision to ignore facts once pride entered the equation. Replaying the 47-minute body camera footage repeatedly and pausing at the moment dispatch confirmed the burglary call was for a different subdivision, and at the moment Hearst said, "She fits," despite no specific suspect description beyond gender and vehicle type. Expert witnesses testified about Fourth Amendment standards, explaining to jurors that reasonable suspicion must be based on articulable facts tied to criminal activity, not generalized assumptions, and statistical analysts presented stop data showing Hearst detained black motorists at nearly 4 times the rate of white motorists in similar patrol conditions. Evidence prosecutors argued demonstrated pattern and intent rather than coincidence. When Judge Whitaker took the stand, she did not dramatize her experience, but instead walked the jury step by step through each legal threshold crossed that night. The initial detention unsupported by matching address, the continued seizure after identity confirmation, the demand to search without probable cause, and finally the arrest for obstruction despite full compliance, and her calm, precise testimony carried more weight than outrage ever could. Defense counsel attempted to argue officer safety concerns and split-second judgment, but under cross-examination Hearst conceded he heard dispatch clarify the wrong address before proceeding with the arrest, a concession that visibly shifted the jury's posture because the case now hinged on willfulness, and ignoring exculpatory information in real time undermined any claim of good faith error. Closing arguments were blunt, the prosecutor stating, "This case is about what happens when authority meets accountability and chooses retaliation," while reminding jurors that 18 U.S.C. Section 242 requires proof that an officer knowingly deprived someone of constitutional rights, a burden they argued had been met beyond reasonable doubt. After 2 days of deliberation, the jury returned guilty verdicts on all counts for Hearst and guilty on aiding and failure to intervene for Dennison. The courtroom silent except for the foreperson's steady voice as each count was read, and months later at sentencing, U.S. District Judge Eleanor McBride addressed Hearst directly, stating that he had been given multiple off-ramps, dispatch clarification, identity verification, visible credentials, yet chose escalation each time, concluding that his conduct was not a misunderstanding but a conscious abuse of authority. She imposed a sentence of 14 years in federal prison, citing the need for deterrence and public trust restoration, while Dennison received 5 years for standing by during a clear constitutional violation, and both men were remanded immediately into federal custody. The fallout rippled through the Atlanta Police Department, which soon entered a federal consent decree mandating independent oversight, annual racial disparity audits, enhanced constitutional training, and early warning review systems for officers with disproportionate stop data. Reforms negotiated in part through a civil settlement in which Judge Whitaker received $3.1 million, but publicly stated that structural change mattered more than compensation. The police chief resigned amid mounting criticism, several supervisors were reassigned or demoted, and internal affairs procedures were rewritten to require statistical analysis before dismissing profiling complaints. Legal commentators from institutions, including Harvard Law School, described the sentence as one of the most significant federal penalties imposed for retaliatory arrest in recent years, emphasizing that the message extended beyond one department. Judge Whitaker returned to the bench after the trial concluded, presiding over cases with the same measured tone she had always maintained, though colleagues noted a sharpened clarity when Fourth Amendment issues arose. And during a public address months later she remarked, "The Constitution does not bend at gated entrances," a line that echoed widely across legal media. She continued to drive through the same Briar Hollow gate each evening, the iron bars sliding open without hesitation, but the patrol cars that once boxed her and now kept their distance, and the case became a teaching example in academies and law schools alike, a reminder that unchecked bias can escalate in minutes, that silence can carry liability, and that when authority is exercised without constitutional foundation, the consequences can extend far beyond a single night's decision. For Hearst, the 14-year sentence meant forfeited pension, permanent decertification, and a career reduced to a cautionary tale studied in ethics courses, while for Dennison it marked a conviction that underscored the duty to intervene. For the community, the verdict restored a measure of faith that accountability, though rare and often delayed, is possible when evidence is clear and juries are willing to confront it. And for Judge Naomi Whitaker, the experience reinforced the principle she had long articulated from the bench, that the rule of law is strongest not when it protects the powerful, but when it restrains power itself.